Good morning, students. I am Dr. Pandiyavadivu, Associate Professor of Education from Tamil Nadu Open University. Today we are going to see the peace education. This is one of the subtitle of your curriculum. It's a prevention of sexual harassment at workplace. This is a topic we are going to deal with that. At workplace, as a student teacher, you might face a lot of sexual harassment in your or harassment of work harassment from your side. How you will overlook that harassment situation, how to tackle the situation, how to avoid the situation, how to manage the situation, what are the rules and regulations are there for against of harassment. Sexual harassment is not a woman's thing. It is a passing bad attitude, something to joke about, something to be ignored. It causes paranoia and fear. It is a requirement to prevent, prohibit, address this issue at a workplace. It is and this is a Bhavani Devi, Indian Delt woman. This is from the one of the village of Vatari from Rajasthan. The story tells about that something how she fight face her problem and how she is overlook that problem and other thing and what are the judgment given against Vishuka guidelines from this different guidelines from this harassment for this judgment how it came uh, against of sexual harassment and another things in Delhi the gang rape cases but the central government appointed a judicial committee and Verma commission and different commissions are there. All these senior politicians, senior leaders, they are fight against the crime. But this continuous harassment is going on so day to day life. When you are go through the newspaper in every day and news from these different channels, we might observe, we might notice several harassment, sexual harassment. So this is advent of law. Status supersedes these Shaka guidelines for prevention of the sexual harassment introduction by the Supreme Court of India. The statute extended to this whole of India. Women Act only for this protection of the woman at workplace. Okay, it is a Burma judges of a Burma committee. They constituted and then enacted the sexual harassment of women at a workplace. It fully covered of prevention, prohibition, and redressal. The Act um, launched in the year 2013 dealt with the sexual harassment of women at a workplace as a prevention, again prohibition, and redressal. And the rules they might framed on 2013. Section 1. What is the basic information, basic law? What are the preambles you should know? So therefore, against sexual harassment, and it is for only women. is an act to provide the protection against sexual harassment of a woman at workplace and for the prevention and redressal of complaints of sexual harassment and for matter connected therewith or incidental thereto. No woman shall be subjected to sexual harassment at any workplace, whether it may be a student or it may be a staff or teaching, non-teaching or any other place, any other stage. No one shall be subjected to sexual harassment in their working environment. What is understanding? The basic. What is sexual harassment and workplace? Aggravated woman. What is aggravated woman? All the women working are visiting any workplace regularly. They might be a regular employee or temporary employee or a dog or daily wages. They engage directly or indirectly. Contractor working for remuneration, voluntary or otherwise. Terms might be employment, may be expressed or implied. They might be they could be co-worker, contract worker, probationary stages, trainees, apprentice, and visitors. These are covered the women working in dwelling place or house. Workplace, it covers the organized and unorganized government organization, private sector organization, hospital, nursing homes, then sports institution, specifically a dwelling or house, any place they are visiting by the employee arising out of or during the course of employment, including transportation provided by the employer. In workplace, that may be extended in office partner, offsites, outboard training, client, anyone where they are working. All places it is coming under this law. What is sexual harassment is bullying or coercing or sexual nature or unwelcoming, inappropriate promises of rewards in the exchange of sexual favor. In most modern legal contexts, sexual harassment is illegal. Sexual harassment is a gross violation of a woman's right to equality and dignity. In Section 2 of the Act, it includes any one or more of the following: physical contact and advances, a damage or request for sexual favor. They may demand and damage the it's a female uh, people's that is mind and even other things, and sexually colored remarks showing pornography, other offensive or derogatory pictures, cartoons, any other unwelcoming physical, verbal and non-verbal contact of sexual nature is called sexual harassment. The following act when relation to behavior of sexual harassment, it may be amount to a sexual harassment. Implied or explicit the promise the preferential treatment in her employment, or third or detrimental treatment in her employment. threat about her present and future employment status, interferences with her work, or creating an intimidating or offensive or hostile work environment for her. Humiliating treatment likely are affecting her health or something else. Form of workplace sexual harassment. Quid pro quo implies the explicit promises, preferential, determinatial treatment in employment. Implied or expressed threat about her present or future employment status. Hostile work environment. Treating hostile, intimidating, or an offensive work environment. They have the treatment, humiliating treatment likely to affect her health and safety. Sexual advances. So, the main sexual advances are demanding sexual favors. Such kind of things. Tonight, our little project team will do great work, great unsavory remarks. Signing, embracing film song. So singing a film song itself the intimation and savory remarks. Jokes causing are likely to cause awkwardness or embarrassment. Okay, cracking joke with the cause of awkwardness or embarrassment. The nudes and taunt. They discriminate on the basis of gender. Gender discrimination. Gender-based insult or sexist remarks. Using gender-based insult. Unwelcoming sexual overtone in any manner. Making absence gesture or using indecent language. Touching or bruising against any part of the body and the life. Hugging, touching someone. Pretext. Displaying pornography or other offensive or derogatory picture, cartoon, pamphlet, or saying something. It is one of the sexual harassment is displaying pornographic materials on the workplace. Forcible physical touch or molestation. Physical confinement against one's will and any other act like violation one privacy. Either standing too close and trying to touch or feel. Abuse of authority or power. In short, the workplace sexual harassment is when the behavior is unwelcoming, sexual in nature, a subjective experience, impact not intent matters. Typically involve act which is a victim has reasonable apprehension that they are humiliating, unsafe, unhealthy, discriminatory, career limiting, otherwise causing adverse circumstances. Sexual harassment is a serious criminal offense. View prevention of IPC 354 assault or criminal force to women with intent to the outrage her modesty. Whoever assault or uses criminal forces to any woman intending to outrage or knowing it to be like that, he will thereby outrage her modesty, shall be punished with imprisonment of either description for a term which may be extended to 2 years, or with fine, or with both. The section under 354A, the Indian Penal Code, the physical contact and advances involving unwelcoming and explicit sexual overture, a demand of a request for a sexual favor, showing pornography against the will of a woman, or making sexual colored remarks, imprisonment for up to 5 years, or fine, or both. In section 294, abhors the obscene act and songs. Whoever to the annoyance of others does any obscene act in any public place, or singing, recites, utter any obscene song, bawd, or bird, or using the filthy language in or near any public places, shall be punished with imprisonment of either description for the term which may be extended to 3 months, or with fine, or with both. Act of 509, word, gesture, or act intended to insult the modesty of a woman. Whoever intending to insult the modesty of any woman utters any word, makes any sound or gesture, or exhibit any object intending that such a word or sound shall be heard, or that such a gesture or object shall be seen by such a woman, or intrudes upon the privacy of such a woman, it shall be punished with a simple imprisonment for a term which may be extended to 1 year, or with fine, or with both. In IPC section 354B, section 354B of the Indian Penal Code, assault or use of a criminal force to women with intent to destroy. Any man who assault or use a criminal force to any woman, or such act with the intention of disturbing or compelling her to be naked, shall be punished with imprisonment, either description for the term which shall not be less than 3 years, but which may extend at 7 years, and shall also be liable to fine. In IPC 354C section 356 Penal Code, voyeurism. Any man who watches or captures the image of a woman engaging in a private act circumstance where she would be usually have this expectation of not being observed either by a preparation or by other persons at the behest of a preparator. Discriminator such as image shall be punished on the first conviction with imprisonment of either description for a term which shall not be less than 1 year, but which may extend to 3 years and shall also be liable to fine and be punished on a second or subsequent. The conviction with the deprivation of either description for a term which shall not be less than 3 years, but which may be extended to 7 years and shall also be liable to fine also. The explanation of this act. For the purpose of this section, Private Act, it includes an act of watching carried out in a place which the circumstances would reasonably be expected to provide privacy and where the victim's genital, posterior, or breast are exposed or covered only a underwear, or the victim is using the elevator, or victim is doing sexual act that is not of a kind of ordinary done in public. When the victim consent to a capture of images or any act this but the discrimination to the third person and which is such an image act is discrimination. Discrimination shall be considered an offence under the section. Stalking. Any man who follow the woman and contact or attempt contact such a woman to foster personal interaction repeatedly despite a clear indication of a distrust by such a woman or monitor the use by the woman of her internet, email, any other form of electronic communication, commit the offence of stalking. Provide that such a conduct shall not amount to stalking if the man who punished it proved that it was punished for a purpose preventing or detecting the crime and the man accused of stalking had been entrusted with the responsibility of prevention and detection of a crime by the state, or it was punished under any law or comply with any condition or requirement imposed by any persons under any law, or in the particular circumstances such conduct was reasonable any justified. Whoever commit the offence of stalking shall be punished on the first conviction with the imprisonment of either description for a term which may be extended to 3 and shall be liable to the fine or punished both. Civil remedy and under the post criminal remedy under the IPC. Prevention and prohibition. Who is responsible and accountable for prevention? What is the role of workplace in prohibition and how? The employer shall create a workplace free of sexual harassment. The workplace, central government, state government, and local authority body, the head or the office. Private workplace, the persons responsible for this management and supervision control. Dwelling house, the person who employ benefit from the employment. Every employer should provide a safe working environment at the workplace, which will include the safety from the persons coming into contact at the workplace. display any conspicuous places in the workplace, penal conscience of sexual harassment and other constituting the internal committee under this law. Organize a workplace and an awareness program. They have to arrange a awareness program at a regular interval for sensitizing the employee with the provisions of Act and orientation the program for the member of the internal committee in the manner as may be prescribed. Provide necessary facility to the internal committee or a local committee as the case may be for dealing with the complaint and conducting an inquiry. What is the duty of employer? It make available such information to the internal committee, the local committee, as a case may be, as it may require, having regard to the complaint made under this law. Provide assistance to the woman if she so choose file a complaint in relation to the offence under the Indian Penal Code 45 of 1860 or any other law for the time being in force. Cause to the plaintiff initiate action under the Indian Penal Code 45 of 1860 or any other law of the time being in force against the perpetrator or if the aggrieved woman so desire, where the perpetrator is not an employee in the workplace at which the incident of a sexual harassment took place. Treat sexual harassment as a misconduct under the service rule. Initiate action for such a misconduct. Monitor the timely submission of the report by the institution. The employer shall create and communicate a detailed policy, ensure awareness of the orientation and the issue, then constitute complaint committee, ensure that complaint committee is trained in skill and capacity, prepare annual report to be submitted to the DO and report the director report. The employee's responsibility prevent or deter the committee of any act of sexual harassment by means of creation of appropriate working condition, ensure the female employees are not treated as sexual object, ensure that no male employee or third party will outrage or insult the modesty of a male colleague, ensure that no male employee or third party will make a type of sexual advances to the female colleague. Establishment of Complaints Committee. Member to hold office for the term not exceeding 3 years. ICC or LCC for each branch. Officers if there are multiple. Function to educate the sensitized employee about the issue. To address the complaint, conduct inquiry. It operates as a quasi-judicial body with the power to summon and enforce attendance, call for evidence documents. Internal Complaint Committee, the chairman, the woman working as a senior level of as an employee, two members from among us these employees committed to the cause of women having legal knowledge, experience in social work, as a member from among us NGO association committed to the causes of women or a person familiar with the victim. If officers are located. This is how the ICC, and it is continuing the German, the eminent working field of the social worker and the member nominated from among this women working place, working in the block, then the district and ward. Two members from amongst this employee committed to the causes the women having legal knowledge and experience in social work. Ex officio member concerned officers dealing with the social welfare of a woman and child. The complaint committee should be thoroughly prepared, know the act, policy, or relevant service rules, gather and record all the relevant information, and determine the main issues in the complaint, prepare relevant interview questions, conduct a necessary interview, ensure the parties are made aware of a process and the right responsibility within it, and analyze the information gathered, prepare the report with the findings and recommendation, and maintain confidence, be impartial, non-retralization, and clinical. Communicating. Education and awareness is a key. So, through education, we are communicate how to behave, how to do work, how we will show our against, how to protect ourselves. Such kind of things we should educate the children. Policy. Employers shall create the policy which prohibits the sexual harassment to take place, and it provides determined framework for the redressal of complaints. Policy to be communicated. It carry out awareness and orientation for all employees and create the forum of the dialogues. It ensures the capacity and skill building for the complaint committee. Widely publicize this name and contact detail a member of a complaint committee. And redress. Section 4. The aggrieved one may make in writing complaint of a sexual harassment at workplace to the complaint committee within a period of 3 months from the date of incident, and in case of the serious incident within a period of 3 months from the date of last incident. The time limit may be extended for another 3 months if CC is satisfied with the reason for the non-filing. If woman is unable to make a complaint in writing, CC to provide for assistance. Who can make a complaint? The woman herself. In case of a mental incapacity, her relative may be give the complaint, her friend may be give the complaint, or special educator may be give the complaint for her, and qualified psychiatrist or psychologist may give the complaint against her for her and guardian under whom she is receiving care. Any person who has information about the incident with written consent of any of the above may give the complaint against the. In case of the physically incapacity, the relative. In case there's a physical incapacity and capability is there means for the affected person, a relative, friends, co-worker, office of the National State Commissioner, any person who have information in this incident, they may give their complaint for that. The complaint, 6 copies by the aggrieved person should contain all the material and relevant details concerning the alleged sexual harassment, which include the name of the container, The complainant date, time, location, working relationship between the parties, name and address of the witnesses. The complaint mechanism. When receiving such a complaint, the chairperson will inform other member of a committee at the earliest possible, and committee will take further step in the matter as required. The first meeting is to be held immediately within the reasonable time, but not later than 7 working days of receiving the written complaint of the aggrieved. The ICC shall investigate the complaint and submit the report containing these findings, recommendation along with relevant documents. In conducting this inquiry, a minimum of 3 members CC, including chairpersons, to be present. On the receipt of the complaint, review the complaint to ensure it has all the information. They have to ensure all the things. The contact of the respondent was towards complaint and is improper and made from a search at workplace. The incident occur in workplace or at any location or any event related to work. The second complaint to the respondent within the 7 days of recipient to the respond within 10 days. Meet up with the complaint for any settlement or conciliation. The conciliation is the conciliation process in the form of verbal warning, counseling, educating, appointment mutual, and conciliator to resolve. Forward the finding, cancellation resolution to the employer. This choice is of the complaint. It initiates the inquiry, interview the complaint, respondent witnesses, listing of the events and fact finding, confidentially and impartially listed. The inquiry process follows the principles of the natural justice order. Example, point R. Terminate the proceedings of if the complaint or respondent failed to be present for 3 consecutive hearings. Legal practitioners are not permitted. The confidentiality to be maintained. Committee must adhere to the rules of natural justice. There are 3 important rules to be observed by the committee: hearing, fair play, and reasoned order. In hearing, nobody can be condemned without being heard. Fair play, the judge must be impartial and act fairly and good faith. Reasoned order. Preventing ongoing a search at the written request of this woman or even otherwise, the CC may be recommended. Restrain the respondent from reporting on work performance of that aggrieved woman, writing her confidential report and appraisal, then supervising her academic activity, transfer the complaints or respondent, place complainant or respondent on leave. Recommendation: in case of allegations are proven, service rule to be followed as for misconduct. Disciplinary actions like written apology, warning, reprimand, reprimand, withholding of promotion, withholding of pay increase or increment, counseling session, community service, terminating from service, financial damages, additional recommendation to address the underlying factor. False or malicious complaint. where the internal committee arrived at a cons- conclusions on that the allegation against this respondent in the malicious or the aggrieved woman or any other person making a complaint has made the complaint knowing it to be false. The aggrieved woman or any other persons making the complaint has produced any forged or misleading documents. It may be recommended to the employer to take action against the woman or the persons who has made complaint, as the case may be, in accordance with the provisions applicable to her or him. Provided further that malicious intent or part of the complaint has been established after an inquiry in accordance with the procedure prescribed before any action is recommended. The timelines are submission of the complaint within 3 months of last incident, notice to the respondent within 7 days of receiving copy of the complaint, then completion of inquiry within 90 days of the complaint, submission of the report ICC by ICC LCC to employer by DO within 10 days of the completion of the inquiry, and implementation and recommendations within 60 days appeal with the 90 days of the recommendation. The Act of prohibit this disclose of content of this complaint, identify and address the complaint respondent and witness, information patient in the continuation and inquiry procedure recommendation of this ICC LCC, action taken by this employer and you, and consequences as per the service rule are rupees 5,000 to be collected by the employer. Monitoring. Submission of annual report. Number of cases received, number of cases disposed, number of cases pending more than 90 days, number of workshop awareness sessions carried out, nature of action taken by the employer. Inspection, make available any informations recorded or documented, include the physical inspections of the workplace mentioned in the director's report. The penalty of by 50,000 where the employer failed to constitute an CC, failed to act on this recommendation of the CC, failed to file the annual report, then controls are per this contribution of the provisions of the Act in event of the repeat of breach. Twice or higher the punishment prescribed. Cancellation, withdrawal, non-renewal of the license registration for carry out the business. Appeal. A person aggrieved by the order of the CC or in the case of non-implementation of this order may file an appeal with the appropriate authority. Either party can be choose to seek justice through this regular court of justice. The summary. Make sure there is a policy that has been effectively communicated to all the workers, irrespective of whether they are paid or volunteers. Display the details, both the informal and formal way available to the worker to address complaint about workplace sexual harassment. Undertake orientation on workplace sexual harassment for all women into the respective organization, establishment, or institution. A complaint committee which trained in terms of skill and capacity critical for building trust. Encourage the senior persons, leaders, supervisors, or any person who can influence employment related decision to become role model. Man and woman should be included in building a culture which no longer tolerate the workplace sexual harassment. And question and answer. Thank you.